Hey, Ben.
Oyez, oyez, oyez. The Honorable Court of Criminal Appeals is now in session. All persons having business before the court are admonished to draw near and give their attention, for the court is now sitting. God save Texas and this honorable court.
Please be seated then.
It's hard to do microphones.
Good morning, everyone. Sorry for starting a bit late. We're glad to have you here today. We have two cases set for oral submission on today's docket. I'm now going to call our first case of the day, AP 77122, Victor Alejandro Godinez versus State of Texas. We will be hearing first from Mr. Garza, counsel for the appellant. I believe you've assigned 15 minutes and 5 for rebuttal. Is that right?
Correct, Your Honor.
Very good. Please proceed.
Thank you, Your Honor. May it please the court, opposing counsel, Rolando Garza for Victor Alejandro Godinez. This is a case out of Hidalgo County. This case came down to a jury determination over causation. Causation has a definition. It's in Chapter 6 of the Penal Code. The statutory definition on concurrent causation has two parts. The first half of the definition states the general principle that a person is responsible for his or her conduct, even when the result is influenced by another's conduct. To wit, a person is criminally responsible if the result would not have occurred but for his conduct, operating either alone or concurrently with another cause, basically but for causation. But for this shooting, we wouldn't be here. However, there's a second half to the definition. The second half of the statutory definition contains an exception to that general principle, which is the unless language. Unless the concurrent cause was clearly sufficient.
Counsel, was there an objection to this part of the instruction?
This instruction was, the second part was not given. It was not
Right, and so
requested.
no one objected to the lack of giving that instruction?
Correct. There was no objection. There was no request for this second half of the definition.
Okay,
And that's the crux of my argument.
sure.
The-
Even if we assume that they should have been given, how can you explain that that might have resulted in egregious harm?
An egregious harm. Well, first, the jury would have to have been given the definition. That way they could at least employ it. Otherwise, it's a legal definition. I don't think it's in common parlance that people would generally, the general public or a juror would say, well, unless the concurring cause was clearly sufficient to produce a result and the conduct of the actor clearly insufficient. I don't believe, unless it's laid out for the jury in instruction.
So
Can you tell us how, I'm sorry.
No, so I was going to
Okay.
say, like, so your argument is essentially, because the instruction wasn't given, it didn't give the defendant an ability to make whatever defense he had. Is that what you're saying?
To have a right to a jury trial, basically.
Okay.
To have a jury pass on this element of an offense, causation, to have the full definition before it in order to have a jury trial at all.
Okay.
I've got a question. So how exactly would this instruction have benefited your client, given the facts of this case?
I've laid out some facts in my briefing as to.
I'm familiar with the facts. I just wonder how you think the giving of this instruction would have helped as opposed to have hurt your client. Because it seems to me that maybe there's a way in which it could help, but there's a lot of ways in which it could hurt your client as well, given the facts of your case. I mean, yes, I understand that the death occurs, 4.5 months later, right?
Approximately.
So, but the conduct of the act, this instruction would require the jury to find, before they gave him the benefit of this, that his conduct was clearly insufficient to cause the result. You think that they can draw that conclusion merely because 4.5 months have passed since the initial shooting?
Well, it's not just the 4.5 months. It was the fact that there was evidence, as I laid out in my briefing, that the trooper survived the shooting, goes to the hospital, has an operation, survives that, it's getting better, doing rehabilitation, is meeting with doctors. Essentially, the doctors make a decision to do this surgery, and then there's to replace part of the skull with a plate. And there's some discussion if this is an elective surgery, was it an elective admission, was it really necessary?
Well, wouldn't
And-
the jury have come down to, well, if he never got shot in the head, then he wouldn't have died?
And that's the biggest problem here, I think. That's the first part of the definition. So left with just that, there's nothing else to consider in his behalf. It's over.
So it's,
You're speaking to us on this issue in two ways, right? You have a sufficiency argument and you have this instruction argument. It's kind of like, it seems to me potentially bookends of the weight of the evidence here, because you've got two halves to this analysis. One is that the cause attributed by your client has to be clearly insufficient, and the alternate cause has to be clearly sufficient, right? So if it's conclusive, if it would be conclusive in the minds of a reasonable juror that being shot in the head with a .357 Magnum at close range is clearly sufficient to cause death, why would it matter? Why would anything else matter with respect to the presence or absence of the instruction or any debate about the second half of that analysis about whether any botched medical intervention could have been sufficient to cause death?
I believe the jury at least has to be given the choice, at least get the full definition, and go ahead and go on their own quandary. And I've gone round and round on this. I mean, I think we can go through different scenarios. We could be here all day on it. I've discussed it with fellow lawyers. I've discussed it with friends. You know, I've discussed it with family. And, you know, there's a case cited by the state called Westbrook versus State. And they note how Section 6.04 provides no standard, and we have found none that would help determine when the conduct of a party, but for which the result in question would not have occurred, is clearly sufficient or clearly insufficient to produce a result. But there's no real standard.
So back to the question I originally asked. How is it that you're saying that this would have resulted in, the lack of this instruction would have resulted in egregious harm to your client?
Basically, the defense counsel argued all of this ad nauseum. I believe I quoted it in my briefing, about 14 pages, you know, noting how the trooper survived. The jury said, well, he survived. He survived, he lived, he was getting better. Was this an elective surgery or elective admission? What was it? Was it really necessary to do this surgery? And ultimately, he's there. They have the second surgery that's conducted.
Well, you're making a lot of good arguments for why it is you think you would be entitled to the instruction, but there's also a lot of other evidence that goes against that evidence that you're talking about. So why is it that we would say, look, even giving this instruction, why couldn't we say, giving this instruction, we still just don't think that there was egregious harm here because there's so much evidence pointing against your theory?
Because it becomes a jury question, much like a lesser included offense. We can all look at it and say, well, this lesser included offense, come on. You know, the judge could say, I don't believe any of that. I don't, you know,
That's fair.
the jury's not going to buy this. I'm not going to give it to him.
So I come back to the observation that I'm sort of asking you too is, so your real theory about this being egregiously harmful is that this was a defensive idea or an argument that was just not able to be presented to the jury, and so the error is the harm.
Correct, in that the statutory definition of both halves, the part that favors the state and the part that favors the defense, wasn't handed over to the jury so they can make their determination.
Okay.
I mean, I guess that's kind of where I am. One of the questions I have is, it's not that he was foreclosed from, I mean, he sounds like he made the argument that he didn't cause the death. Whether or not there was a concurrent causation instruction, he wasn't foreclosed from making the argument. I mean, I think what you're maybe asking us to do is to imagine a scenario where a jury would have acquitted him. I mean, that is what you're doing. You're asking us to imagine a scenario where the jury would have acquitted him if he had concurrent causations, but they didn't acquit him. Like, at least in a lesser included offense, like, there's literally no place on the verdict form to give somebody a lesser included offense if it's not put in there. But here, they could have just found him not guilty. They could have just said, well, he didn't cause the death, the doctor did, without the concurrent causation. How do you square that?
Okay, argument of counsel, the courts are, I can't point exactly in the record, it must have happened, where the trial court tells the jury repeatedly, probably since the beginning of jury selection, for what the lawyers say, you know, that's just argument. You know, what's going to be important is the instructions I give you. The instructions I give you is what you need to follow. They're going to get up there and they're going to do their thing. But in the end, I am going to give you the law that you will follow.
Yeah, but the law that was given was, unless you find beyond a reasonable doubt that he caused the death of this individual, you will find him, I mean, that's already in there, right?
Not the statutory definition of causation.
No, there's a definition, just not to concurrent causation, but you still have to prove, I mean, the state has to prove no matter what that he caused the death of an individual, right?
The state does need to prove that. However, criminal causation has a very particular definition with two halves.
Okay.
So one of the things that I am really interested in is whether this instruction is, in a case like this, because of the facts, does this instruction become automatically law of the case? Or is it one of those instructions that would be more like a defensive instruction where the defense can decide to ask for it, in which case it becomes law of the case and the judge has to instruct on it? Or the defense might say, that instruction's not going to help me, I'm not going to ask for it, and so the trial judge is, under that circumstance, if it is a defensive, truly a defensive issue, remember like a self-defense or a lesser included offense, one of those defensive instructions where if it's not requested, it's not even error.
Under Texas Penal Code 2.03, defenses are labeled as such. A defensive prosecution for an offense in this code is so labeled by the phrase, it is a defensive prosecution. This is not labeled that way. Under Section 2.04 of the Texas Penal Code, an affirmative defense in this code is so labeled by the phrase, it is an affirmative defensive prosecution. That's not any part of this definition.
Well, but
it's not in
it's
Chapter
not-
8, it's not in, oh, I'm sorry.
It's all right. It's not only the defenses that are considered defensive instructions, but also lesser included offenses are considered defensive instructions. So that, for example, if they're not requested, they're not necessarily, it's not error not to give it if nobody asks for it. And I'm wondering if this instruction that you're saying that your client was entitled to, is it more of a defensive instruction such that it's not even error to fail to instruct on it, or does the court have to instruct on it anytime there's some evidence that some other thing might have been at play in causing the death?
I think the definition, it just adds clarity to the element, and I believe that the court should have instructed as such.
Do you think that the court a trial court can get away without instructing the jury on causation unless someone asks for it in a murder case?
Depends on whether there's a request, not a request, was it?
That's what I'm
was it the
asking. Do you think that you would have, as the defense would have to request that the jury be instructed on the issue of causation completely in a murder case? Or do you think it's just something that the jury has to be asked?
I think it would depend on the evidence, such as the evidence in this case, to trigger the trial court's function, giving the complete definition.
Okay.
Counsel, let me ask you a question. Trooper Sanchez was in a coma and unresponsive from the moment he left the scene until the moment he died, correct?
That's open to debate. That was the state side, their part of causation, and then there was a defense side, which had a much different view and presented a much different case as to where, in the end, the last surgery, the neurosurgeon came out, basically told the family he's going to be okay, he's fine, and then he was extubated. A breathing tube was taken out prematurely from him, and that led to seizures and death. And that was the defense side. And again, it all comes back to a jury trial. Let the jury
Okay.
decide.
But what evidence would I look to in the record that would support the contention that the evidence was clearly insufficient to produce the result? In other words, that the defendant's conduct, the evidence showed the defendant's conduct was clearly insufficient to produce the result. What evidence would I look to?
Basically, what the defense counsel laid out and what's in my brief, that he survived the shooting, he was getting better, he was undergoing therapy, he'd been meeting with doctors, they'd scheduled this other operation, that there was questions, was it really needed, not needed, was it an elective surgery, was it an elective admission, whatever that meant, and the second surgery was declared a success in real time by the neurosurgeon.
Counsel, somebody gets shot on the side of the road, the EMTs show up and they just kind of stand around and look at the guy and go, man, that looks really bad, and they don't do anything and the guy dies. Would you think that there should be a concurrent causation instruction in a murder case following from that?
Being lack of medical treatment, is that the?
Yeah.
Yeah, shot with a .22 in the abdomen and left for 4 days to watch.
Sure, and this was what I was getting at earlier when I was talking about Westbrook, about how there's no real guidance, and to see how we can go by different scenarios all day. And Westbrook goes on to note this other part. Let me just go ahead and they make note to the practice commentary in the annotated statutes suggests that this language, which was this clearly sufficient or clearly insufficient language, is used to free the penal law from encrusted precedents on proximate causation, offering a principle that will permit both courts and juries to begin afresh in facing problems of this kind. Being freed from encrusted precedents, we are left without authoritative guidance. We conclude that causation, being a concept too difficult for lawyers or even for philosophers, is best left to the jury, because we can do this all day. And this is what, it's a difficult concept, even for lawyers or philosophers. Just leave it to the jury. Leave it to the
The
jury.
statute does, though, with respect to, this is a special kind of causation. You have arguably concurrent causation. That's the point of Judge McClure's question to you of, at what point is it triggered to say something's a cause? Inactivity could be a cause. If you or I blew somebody up with a stick of dynamite, you could make the argument, well, if his mother had never given birth to him, he wouldn't have been there to get blown up, so maybe there's a concurrent cause there too, right? So at some point, there needs to be affirmative action, potentially, but the statute itself gives us, our judges, guidance here, but because it has clearly sufficient and clearly insufficient on both ends. Isn't that some significant guidance?
Could be.
Yeah. Okay, you have some time for rebuttal. Thank you.
sorry.
We'll now hear from Mr. Wood.
May it please the court, presiding judge, members of the court, opposing counsel. My name is Rodolfo Martinez, Jr.
I have a little trouble hearing you. Both of you had the trouble. If you could pull the microphones a little closer to you, that probably would be helpful. There you go. Thank you.
All right. Good morning. My name is Rodolfo Martinez, Jr. I'm here on behalf of the state, along with my co-counsel, Roxana Salinas. We're from Hidalgo County, the Hidalgo County Criminal District Attorney's Office.
I'm sorry, I misintroduced you as counsel for the next case.
Yes,
My forgiveness.
that's all right. Yes, my name is Rodolfo Martinez from Hidalgo County. And yes, we're here to discuss, there was 4 issues that were brought up, and we're here the issues that were designated were issue number 2 and issue number 4. In this case, the concurrent cause instruction that appellant claims should have been given, there was no facts to support issuing such an instruction. The concurrent cause definition is under 6.04. And in there's 2 requirements that are needed in order to be given the instruction. There has to be evidence that there was an agency, in addition to the actor, there was a but-for cause of the result charged.
You don't think that a surgery being performed on the guy could potentially be an agency that contributed even to the death?
That is,
I mean, that's some evidence.
usually the examples given of a concurrent cause are usually things that are happening simultaneously, I would say. In the Sear v. State case by this court, it gives the example of 2 arsonists burning buildings at the same time, one on one end, one at the other end. It's happening concurrently at the same time. That's more of an issue of concurrent cause.
Well, this guy did not die on the day he was shot.
That's
He
correct.
stayed alive, until they had a surgery on the guy, and then, and then he expired. So, I mean, don't you see the argument there, at least factually?
I mean, I do I see the argument. I do believe, though, that he was not entitled to the instruction, because the Sear v. State case does lay out that both prongs are necessary.
Right.
And one of the prongs includes that the appellant's conduct itself has to be clearly insufficient to cause the harm. I think he certainly loses on that prong.
That's the prong I want you to focus on.
Okay. Yes,
Trooper Sanchez was shot in the head,
correct. Close
causing
range.
massive brain damage, which ultimately increased the pressure in the head, causing hypoxic ischemia, which was the principal cause of death.
That's
How is there evidence that, if we use that second part, the defendant's conduct was clearly insufficient to produce the result?
that's exactly correct. The conduct of shooting somebody in the head, close range with a .357 Magnum, is always going to be an act that's capable of causing the result in this case, which was the death of Trooper Moises Sanchez.
Can you shed some light on the dispute as to whether or not he was in a coma the entire time?
He was that, and The
The defense says no, correct?
That's correct. I don't think there was any evidence that he was actually getting any better. The defense did
Not any
point.
better, but did he actually come out of the coma and talk to anybody during that time?
No, there was no evidence of that that was presented in the record. The appellant did point out to the fact that there was healing on the outside of his head. However, the expert, Dr. Sandberg, testified that the deterioration commenced when the bullet hit the brain. That's when he started deteriorating, and that's what led to the hypoxia ischemia, which ultimately led to his death. But all of this, of course, was commenced from the appellant's actions himself, which was the cause of his death.
Well, let me ask you this. So I get annoyed, I get pulled over for speeding and I'm annoyed at the police officer and I poke him in the eye with a dirty fingernail. And then he goes to the hospital and they completely mess everything up and he dies from sepsis. How am I not on the hook from capital murder at that point?
Well, it depends on whether or not it was an act capable of causing,
I mean, I poked him in the eye, so it's an act capable of causing serious bodily injury, right?
that's correct.
So am I on the hook for capital murder, even though my goal was, hey,
Arguably,
aren't you blind? You didn't see me speeding, boop, and then he dies of sepsis. Like, how am I not on the hook for capital murder at that point?
arguably you would be, yes.
Okay.
Arguably you would be.
At least you're consistent, all right.
Yes.
How does the access, just theoretical access to medical care factor into the first part of this analysis? Act clearly capable of causing death, right? So we've got someone who commits an offense that doesn't immediately kill somebody. There is always the prospect of getting them to a physician. And then there's the potential for that person to be saved by competent or perhaps exceptional or extraordinary, and those things are deprived to the victim. If it's possible to have saved the person, is it at the front end also carried back into the question of whether the act was clearly capable of causing death? Because medical intervention is always available.
That's correct. I would say yes. It does tie back to the defendant's conduct that commenced this need for medical care to begin with. And in fact, there is a case out of El Paso. I did cite it in my brief, Leslie State. It's a 2012 case, wherein that court held that the appellant was not entitled to a concurrent cause instruction, where there was arguably questionable medical treatment. They said that the placement of a left chest tube might have caused injury. However, they said he was still not entitled to the instruction because his act of stabbing the victim was an act clearly sufficient to cause the death.
So in theory, the trial judge deciding whether to give this instruction or not should be asking, assume there is no such thing as medical care anymore, right? When the actor did the act, if it was clearly capable of causing death,
I think it would.
that'd be enough.
I think the court would have to make the analysis on both prongs in order to make the determination, for sure.
So again, I want to draw your attention back to this question that I'm struggling with a little bit about whether or not this instruction is one that is always applicable to the facts, right? In other words, is it a defensive instruction? Is it only warranted when one of the parties asks for it? Or any time that there is evidence that there may have been some other intervening factor, does it become law of the case so that the trial judge errs by not giving the instruction?
It depends on the facts that are presented in
So the facts can raise it, and that the facts themselves would require the judge to give the instruction.
Correct.
So there's no need for one of the parties to say, I would like to have a causation instruction here, Judge. The judge is just kind of required to give it.
Correct.
Okay.
Well, wait, would that be true, the hypothetical I gave earlier? I put a case of dynamite underneath somebody and blow them up, right? That act is clearly capable of causing death. Why would in a case like that, the judge be compelled, if no reasonable juror could come to any conclusion other than that the defendant's act was sufficient in and of itself to cause death? Why would he have to go further?
Well, I don't think you would have to give the instruction in that.
Okay, so that's
scenario.
that would be the first question.
Right.
Do the facts in this case lend themselves to such the possible conclusion by a reasonable juror that the defendant's act did not cause the death?
I do not believe so. I think a firearm is a per se deadly weapon, so I don't even think it has to be an expert that can conclude that this was an act capable of causing death. However, that's exactly what the experts did testify to, that it was death from complications from the gunshot wound. So yes, and then I think really what's going on here is that appellant is conflating the element of causation, just regular causation, with concurrent causation in trying to say that he was entitled to that instruction. But there's a difference between just but for regular causation, the element of the offense, and concurrent causation. I don't think this is a situation wherein the concurrent causation was warranted.
Do you think there's a time element here? Like, let's say, the trooper lived for 3 years and then this happened. Like, at what point is enough time passed where now we can start talking about concurrent causation?
I think it's possible. I think if the trooper would have made a complete recovery and been better than he was, got a complete recovery and then died from something
So, yeah,
else.
so the trooper gets well, but let's say experiences dizzy spells, and then one day is walking the dog and falls over, hits his head and dies. Is that it? Do we have a capital murder? And if we have a capital murder, do we have a
It would
concurrent
depend on-
causation issue?
Yeah, it would depend on whether or not the experts in the testimony can link it to the appellant being the cause of the.
But I mean, let's just say, like, there's no doubt, like, he was dizzy because he got shot in the head, and because he was dizzy, he fell and hit his head on the sidewalk and died.
Arguably, yeah, I think
Okay.
that maybe the instruction would be given then. But yeah, but that was not the situation in this case. I think also, onto Judge Newell's point regarding the harm, there was no objection so it is an egregious harm analysis in this case. I think there was overwhelming evidence on the causation issue. I think that also he was not precluded from making the argument of attacking that there was reasonable doubt on the causation issue. In fact, the arguments were pretty extensive on that point. So it was definitely harmless error because of that. I don't think they can meet the egregious harm point on this issue, and they were not entitled to the instruction to begin with. On to issue number 4, that was also designated for oral argument. The appellant complains of all the non-privileged jail communications that were monitored by the trial counsel.
Were any of them used?
Only one of them was entered in evidence, and it was a letter from the appellant himself wherein he signed his name as trooper.
None of the phone calls were used.
But the phone calls were not admitted. No, the trial judge did not permit the admission of the phone calls where he refers to himself as trooper.
What was the point of admitting that piece of evidence that was admitted?
The fact that he had a lack of remorse, I would say. It was during the punishment phase, not during the guilt innocence phase.
So just to be clear, none of this material was offered at any time during the guilt innocence phase?
Correct, that's correct. That is correct. This was admitted at the guilt innocence phase. Additionally, there was evidence, apart from the non-privileged jail communications wherein he referred to himself as trooper. In his, there was his disciplinary records that were admitted wherein he signed his name on a bench in his jail cell as trooper, and that was not part of it. So even if you considered it erroneous for us to admit it, it would have nonetheless been harmless because it was admitted somewhere else. But yes, to prevail under the Equal Protection Clause, they have to show that the party was treated differently than other similarly situated parties, and that the differential treatment did not have a rational government basis. I think they fell on both of these prongs. This was a case.
Was the amount of the bond ever attacked?
I believe they did lower the bond, but he was not to a point where he could get out. He stayed in custody the
But was there
entire
any
time.
argument made the bond was excessive?
I'm sure there was, but I'm not exactly sure. But that's probably how it did happen, but I don't recall off the top of my head.
I'm not sure how things work in Hidalgo County, but when, let's say, some rich person with all kinds of money goes out and shoots a police officer in the head, leaving him to be, hospitalized in a coma for months and months, is that person likely to get out on bail while they're waiting trial?
No, not at all, not at all. That's a very serious offense, and that's why the other factors when setting bail include the severity of the offense, the nature of the offense, the safety of the community, all of which have nothing to do with whether or not he's indigent or whether or not he has money. In fact, if he does have money, because of the severity, the judges can be inclined to even give a higher bond. That's a very.
Isn't capital murder where you're seeking the death penalty one of the few circumstances where you don't even have to give bail?
That's correct. Under the Texas Constitution, it is possible for the district court not to give a bail amount at all for capital offenses. And in this case, he was charged with 3 capital offenses. The one that we're here for, the capital murder that we're here and before this court, and then 2 attempted capital murders that are pending in the 13th Court of Appeals. Yes. But yes, I also, even assuming that there was a violation of his equal protection rights, he would still have to show that it had to be suppressed. There is a case out of this court, ex parte Aparicio. It's a 2024 case, wherein this court cited to the Sixth Circuit in the footnote 43 specifically, where it says, "We are aware of no court that has ever applied the exclusionary rule for a violation of the 14th Amendment to Equal Protection Clause." So even assuming it was, and they didn't have a rational basis, he would still have to show how the exclusionary rule would apply. But yes, there was actually a rational basis. I wanted to bring that up as well. At the trial level and in his brief, counsel does point out that he does recognize that the jail does have a rational basis for monitoring these non-privileged jail communications for the safety of the jail. And then there was also testimony from the person that testified regarding the letters to that effect as well, that they would review the letters, make sure there was no staples or anything like that the inmates can use to make tattoos or anything to that effect that would jeopardize the safety of the facility. I think that's pretty much it. I don't know if there's any other questions regarding these 2 issues.
No, Mr. Martinez, thank you very much for your time. We'll hear from Mr. Garza for 5 more minutes.
Thank you, Judge.
Okay. So all of Godinez's communications, visits, texting, everything was doing was being monitored wholesale by the state. Anything he says, it could be something innocuous, whether they're talking about mom, about religion or anything like that. This could affect his mitigation, things of that nature. So the prosecutor went on for a good while, and I quoted extensively in my brief. In fact, I think I probably went too many pages of quotations, but at any rate, where the prosecutor is talking about, if mom goes up and testifies, I'm ready to impeach her. If sister comes up and ready to testify, I'm ready to impeach her. I've got this other evidence, actually, Judge, I've got this other evidence, this letter, I got this phone call. The only reason the phone call didn't come in the end is because it wasn't interpreted ahead of time, and the judge had an issue with that. Had it been interpreted, the phone call probably would have come in.
You know what, when you say, I don't know, I don't think you're making this argument, but it almost sounds like what you're saying is it's not fair that I couldn't get my witnesses to lie because they would have been impeached by the stuff that the state knew.
Well, at least now the state is prepared for it, right? And still, if someone's going to take the stand and testifies falsely, you can impeach them. But at least now they're building up their case, their background. They know what to fish for. They know what to look for. They've got everything in front of them. How about that time when you and Godinez went to the park and whatever?
So almost like they knew, they knew too much.
Like, yes,
they knew too
that
much.
happened.
Okay.
Just stuff like that.
Kind of like the surveillance state on steroids, right?
Right. Everything's being monitored. It just doesn't seem fair. It just doesn't seem fair. And I want to get to just an issue about a remedy here, because that's probably something I really needed to probably brush up on. I mean, this is just by way of example. I'm not making a Fourth Amendment claim here. But under the Fourth Amendment, people are, supposed to be secure from unreasonable searches and seizures. There's nothing in the Fourth Amendment that goes on to say, and if there's a violation, then we're going to do this, that, and the other thing. But we have suppression, to enforce the Fourth Amendment, to give it some honor, and to bestow it upon the people. Kind of like Miranda. Miranda, we've got, it's a prophylactic measure for the, right to remain silent. It's a constitutional right to remain silent. It should be enforceable. It should be given some honor. It should be bestowed upon the people. Right to counsel, same thing, right?
Counsel, I hear what you're saying, but you have to explain this for me. The jail treats everyone inside the same, whether they're a billionaire or dirt poor. Everyone that's incarcerated knows their phone calls are monitored, their mail is monitored, period. Now, it may be there's an external set of factors that has an influence on whether a person can post bond or not. But there's no discrimination based on their wealth or earning capacity. As I'm seeing this, the jail treats everyone that's incarcerated the same. So you've got to explain this equal protection angle to me, because I'm not seeing it.
The argument is, you have people who are arrested, and you'd like to think if they have basically the same criminal offense, maybe the same background, that they get a bonds reasonably about the same. Those who have money can get out, and their actions are not being monitored.
Is it your position that cop killers, people who shoot a cop in the head with a .357, are going to get out in this situation? I mean,
It's possible. I mean,
is there not a likelihood that the court would set a higher bond for someone in this situation that the court thought might be able to make it?
correct. A judge has all different factors to look at as setting the bond, but ultimately, the person is up to them whether or not they can bond out or not.
Is your argument that he's just, wealth disparity just makes it less likely that someone who is poor would be able to afford any bond at all? Right? Isn't that, that's how I understood your argument.
That could be part of it. That could be part of it, or just can't reach whatever dollar amount is given. And just on that point about granting no bond, there was never any kind of hearing as to granting no bond for Mr. Godinez. And in fact, you would have to basically have a mini trial to get to that point of no bond.
Was there a hearing on a motion that the bond was excessive, or a claim to reduce the bond?
I don't recall that.
The issue this is directed at ever presented to the judge to say, bond is excessive, there's an issue here?
Not in that regard, but when the motion was being argued, defense counsel repeatedly told the court, if Mr. Godinez had the money, he'd bond out. He'd bond out if he had the money. And actually, even the
Supreme
state.
Court, and I think it was Rodriguez in the 80s or 70s, rejected income disparity as a suspect classification, right? So, and the whole point of a right to bond in the federal or the U.S. Constitution is because it's better to not be in prison, because one of the things you lose there is privacy. So it's all baked into the same pie, right? I mean, you've got a right to bail. If you can't make the bail, you're going to be in jail, but that's true as to everybody, right?
Not those who can post bond.
Counsel, you have to convince me that this is wealth-based as opposed to custody-based, and you're not doing it.
Your Honor, I'm just going to rely on my briefing on that issue. He couldn't make the bond. The state pretty much conceded that point, that even though he can't afford to get out on bond, he loses his privacy rights, sure. Now, I did have a case of Elphinson there about how, there's still the presumption of innocence when you're there. That while the state can go over your stuff for penological interests, the state shouldn't just be allowed to just go through all of your stuff. in
Assuming for
preparation
the sake
trial.
of argument that some of us might see what the point you're trying to make happens to be, right? Kind of see your argument, okay? Where's the line, right? Like, is there anything that an incarcerated person can do or say while they're incarcerated, awaiting trial, that might be admissible? Or is it, in your view, should it just be automatically suppressed in all cases? Because it happened while they were incarcerated, they didn't have a choice to be there. Where's the line?
And I think that's the quandary of defense counsel. When you start trying to see where is that remedy, how do you?
Why I'm asking.
Yes, exactly. Well, defense counsel said, well, wait, okay, let's stop this. Let's stop this practice of handing over all this information. Maybe the trial court can filter through some of this to see what would be admissible or not admissible. So defense counsel at the trial court level was trying to figure out a way to craft it, and that was one of the things he suggested. And that was shot down. And then after that, maybe you can go item by item. It was so voluminous. The stuff was so voluminous. Defense counsel said, Judge, please let them designate, well, what call, what letter? I mean, we're getting waves of this stuff, and it's not ending. It just keeps on coming. But you can go item by item and then determine what will be admissible and what won't be admissible.
Wouldn't your argument extend to a situation where someone's incarcerated pending trial and they find contraband in their cell, a shank, for instance, and they come to the court and argue to suppress the shank because if they had been able to make bond, the police wouldn't have been able to search their home and find the shank?
Isn't that effectively the same argument you're making here?
Well, that goes against penological interest, you know, you can go ahead and go into the cell, that's a Fourth Amendment argument. You can go ahead and see.
Don't the same interests allow the penal officers to supervise phone calls?
Sure, for penological interest, to see, you know, an escape.
And
an
what
assault.
mail goes out and in?
They can do that for their own interest, but this was just a prosecution team just hoarding anything that he did. And also, just the thing about the trooper on a wall there at the prison earlier, or the jail actually, I don't think anyone ever admitted that it was him that actually wrote that, or who wrote that onto that wall.
Thank you, Mr. Garza.
Okay.
With that, this case will now be taken under submission. Thank you very much to both counsel for your time here today. I'm now going to call our next case on the docket, PD 0449-25, SHEDRICK Joseph Baptiste versus the State of Texas. Now, we will hear from Mr. Wood, counsel for appellant in this matter. Mr. Wood, you're taking 15 minutes and reserving 5, if I have that correct. Is that right?
That's correct, Presiding Judge Shank. I was thinking I was going to have to say, Professor Muldrow, I am not prepared today. Good morning, and may it please the court. My name is Ted Wood. I work for the Harris County Public Defender's Office, and I represent Mr. SHEDRICK Baptiste in this appeal. This is a great opportunity for me to be here. It's the third opportunity I've had to present oral argument to this court, and I think this is the most significant of the 3 cases that I've been involved with here. And that's because this case directly concerns the Texas Constitution, and not just any provision of the Texas Constitution, but Article 5. And as you all know, Article 5 creates the judicial department, if you will, of the state of Texas. This appeal is a little bit unlike others that you hear. There's nothing to do with substantive criminal law. There's very little, if anything, to do with criminal procedure. But rather what we're talking about today is basic Texas civics.
Well, we're talking about power, right?
We sure are.
And accountability.
Yes, sir.
Okay.
Yes, sir. And that's why I say it's about Texas civics, because civics is really about how government works and why. So specifically here, we're talking about how does the judicial branch work in Texas, and why does it work that way? At issue today is the constitutionality of 2 statutes in Chapter 54A of the Government Code. And those statutes authorize the associate judge, an unelected person, to conduct voir dire. And it's my contention that those statutes violate Sections 1, 7, and 8 of Article 5.
Does that make
of
this
the
a Marin
Texas
3 right?
Constitution. I'm sorry.
Does
Judge.
that make this a Marin 3 right?
No, I believe this is a Marin Category 1 right. I believe this is something that cannot be waived, and it cannot even be agreed to.
So how do you get around Karenev?
Okay. Karenev is the case that the state's going to rely on very heavily, saying that you cannot challenge the facial constitutionality of a statute for the first time on appeal. But there's an entirely separate line of cases saying that you can always challenge a void judgment. You can attack that at any time, including for the first time on appeal. And what I'm talking about here is akin to jurisdiction. It's not jurisdiction. Jurisdiction belongs to courts and not to individual judges. But it is akin to jurisdiction in that we're talking about the qualifications of a judge to act. And when a judge does not have the qualifications to act, then we have a void judgment. And so that's not even covered by Karenov. It's a completely different line of cases. There's no need for this court to have to overrule Karenov or anything like that.
Was there a case called French that you cited us to that involved something similar to, I believe that we had a municipal judge who had not taken the oath? And we found that to be void, is that correct?
I believe that's true, yes. Yeah. You know, there are several cases where the use of an unqualified judge renders the conviction void, and they're from this court, 5 cases from this court. I think what's really sort of helpful too, I can list those if you need them, they're in my briefing, but Judge Yeary wrote a concurring and dissenting opinion in a case called Smith v. State in 2015, and Judge Yeary, you've been here a decade or more now, so I don't expect you to recall everything with great clarity. But what you said there was that a right is a Category 1 Marin right if its enforcement is not optional with the parties. And here, the defendant could not waive the right to have a qualified judge. That's required. That's a requirement. And I think that's good counsel, what you said there about a Marin Category 1 right.
If this is a Marin, I'm sorry, go ahead, Judge.
At the risk of being offensive to an associate judge, did the associate judge actually do, I know you're gonna say pick the jury, but like, is that actually doing anything? Like, what is that? What is picking a jury?
Well, I'm going to answer it this way, Judge McClure. There are many decisions that are made during jury picking, if you will, jury selection, voir dire, that are grounds for reversing convictions. And
Can't the same be said for a motion to suppress evidence? Can an associate judge not hear a motion to suppress evidence?
Judge Yeary, I'm not actually sure if that's one of the things that they can hear or not. I'd have to go back to the listing.
I'll ask another question. Is a motion to suppress an interlocutory determination that could be revisited by the real judge when he's come in?
Well, possibly. There is some language in Chapter 54 that talks about the elected judge being able to review decisions for 30 days.
Well,
that kind of
that's,
thing.
I was going to ask both sides about that, because I looked through all of Chapter 54, and it is quite telling to me the distinctions between the purported authorizations in 54A with respect to criminal associate judges and civil associate judges, in that there is the right to de novo review of determinations made by a civil judge. I didn't see that. Perhaps I've missed it. Maybe the parties could correct me. But that is a sort of defining feature in the federal system, and it has been sort of heavily focused on by the U.S. Supreme Court with respect to non-Article III judges in the bankruptcy court, in Marathon and Stern, and in the magistrate setting. And I'm going to talk about the Peretz case and the case before it. I don't know if you've had a chance to read the SPA's brief on that, but am I right in that there is no guaranteed, there's neither a requirement of consent for the associate judge to conduct anything in a criminal proceeding, or a guaranteed right of review of any potentially dispositive ruling that the associate judge has made? Is that correct?
Just about correct. And yes, I am familiar with Peretz, thanks to the state prosecuting attorney's brief. I will say that it seems that the civil associate judges, there's a greater deference to the elected judge on the decisions they make, a greater form of review.
You're sort of hitting on a nerve there with me.
Okay.
Is a criminal judge or a criminal proceeding of less consequence than a civil one?
Of course not.
Yeah, I would think not. With respect to Peretz, that was decided a year after a case called Gomez. Are you familiar with Gomez?
1989, U.S. Supreme Court, yes,
What
sir.
did Gomez say about having a magistrate judge conduct voir dire without the consent that was present in Peretz? It can't be done, right?
I think, if I'm remembering Gomez correctly, they said that the district judge cannot meaningfully review voir dire because of all the different decisions that are made. And I think this goes back to what you were saying, Judge McClure, is what difference does it make picking a jury, so what, you end up with people. And what I was saying is that in Gomez, it says there are many different errors that are grounds for reversal in voir dire. And you think about what happens there. The trial judge is asked to rule on challenges for cause. The trial judge is asked to rule on everything associated with a Batson challenge. They're sometimes confronted with issues about closing the courtroom to loved ones of the person who's on trial during the voir dire process. There's questions about improper commitment questions, rulings on that. Often, a fertile ground of appeal in voir dire proceedings is the time limits that the trial judge will put on the attorneys. And
Counsel,
so- yes,
you're
sir.
right, but I have a slightly aligned question.
Sure.
If this is a Marin Category 1,
Yes, sir.
if it's a constitutional violation that can be raised on the first time in appeal,
Yes.
what are the implications for the tens of thousands of convictions that associate judges have been involved in?
Well, that's a great question. And Judge Finley, it's a question for another day.
Counsel, I wanted to ask you something.
Yes, sir.
You had given an example of a void judgment where, say, we were talking about jurisdiction or the idea that a judge didn't swear an oath and therefore the judgment was void for that. But that's a situation where the judge isn't necessarily complying with an existing statute that would require the oath. But here, this is a statute that does exist and the associate judge was in compliance with the statute. Do you have any other examples of situations where there's a void judgment where the judge actually did comply with the existing statute and nevertheless we said that statute is unconstitutional, therefore the judgment is void?
I have an answer to that question, but it's not as specific as what you're looking for,
Okay.
Judge Newell. And I go back to a case that doesn't have anything to do with judges, but it has to do with congressmen, and it has to do with senators. And it's out of the U.S. Supreme Court. It's called U.S. Term Limits versus Thornton, 1995, a unanimous opinion authored by John Paul Stevens. And what was at issue in this case was a constitutional provision that was passed in Arkansas. They amended their own constitution to put term limits on congressmen, U.S. congressmen, and U.S. senators. That got challenged. And what the U.S. Supreme Court said is, no, you can't do that, Arkansas, because the two qualifications clauses in the U.S. Constitution that set out the qualifications to be a congressman and the qualifications to be a senator, that covers the whole ground. That covers the entire field. And so you're not free as a legislature to prepare a constitutional amendment, which I imagine was approved by the people of Arkansas, because it runs afoul
Right.
of the U.S. Constitution. And so that's what we have here. We have Article 5 of the Texas Constitution, which in Section 1 says, yes, sir.
I agree with you
Okay.
in general terms
Okay.
about the idea that, yes, I don't think the legislature could pass an unconstitutional statute. But Karenif allows for the idea that just that they passed the statute, and because they passed it, we are at least to presume that it is constitutional until there is a challenge. And so that would seem to me to get in the way of being able to say that this judgment is void because there's a valid statute that hasn't been declared unconstitutional. Now, if it's declared unconstitutional, then yes, I can see everything being void.
Yeah, I understand exactly what you're saying,
Okay.
Judge Newell. And what I think is that Karenev is really talking about penal statutes, okay? Something on the order of ex parte
That's a very
low.
good point. I always thought the Karenev was about sufficiency of the evidence, not necessarily about the constitutional challenge. So please continue.
Okay.
Can I interrupt just for
Sure,
a minute?
sure, yeah.
So Judge Schenck asked a question a little while ago that made me think that perhaps he thinks there is a difference between rulings that an associate judge might make that then might be re-reviewable by the district court judge, like a motion to suppress, for example.
Yeah.
Interlocutory, though it may be, it can be raised again later in the trial when you get an actual district judge who gets to review that question. So, but in this case, you've got, all the associate judge does is the picking of the jury, right? So why couldn't, if the district judge came in, which I think he did in this case, he came in to try the case, both
Sure.
guilt and punishment, and why couldn't the party have said, hey, we want you to bust this panel, the associate judge did it all wrong and he made the wrong rulings, and so bust the panel, let's start over again, and this way you can handle things the way you should.
I think that's possible.
Yeah.
I think that could happen. I've never seen it happen.
I mean,
Are there things that are done during jury
Counsel-
selection that are short of busting the panel as a remedy?
I'm sorry,
Are there concerns that would come up during jury selection that would potentially fall short of busting the whole panel and starting over again?
and so
a
could those be
single-
brought to the attention of the elected district judge? Is that what
Right.
you're saying? I suppose they could. I do know that the whole entire purpose of this is to streamline procedures, give the elected district judge more time to handle other matters, because voir dire, let's face it, it's a time-consuming practice. But as a practical matter, in Harris County, where associate judges have historically been used, the jury selection is done, and the only thing that the elected judge does is formally swear them in.
Counsel, could
Yes,
you
sir.
answer my question?
Let me try, would you try me again, Judge Newell?
Yes, basically, I wanted to know, the idea behind Karenov is the idea that we presume a statute is constitutional unless there's been a challenge. How does that affect your void judgment analysis or the ability to bring this up as a void judgment?
This is the challenge,
Yeah.
right here, right now. I'm challenging it.
Right, but you, under Karenov, you would be required to have made the objection in the trial court in order to be able to raise it for the first time.
I understand my time's up, I'll just answer that question. And that is that Karenov is a completely different set of circumstances. It's a challenge to a penal statute that creates the offense in the first place. When we talk about a statute that has jurisdictional or qualification implications, then I believe that can be raised for the first time on
Okay.
appeal.
Okay, I hear you.
Before you sit down, and you can think about this when you come back.
Okay.
2 questions. Is it your position that in some of the larger counties, when you bring in an entire panel of individuals who are initially qualified, that associate judges don't have the authority to do that either? And second, visiting judges are a creation of the legislature, not the Constitution. But throughout the state, they are constantly picking juries. Is your position that they have no authority to do that either?
My position
And you
is.
can answer that when you come back.
I'll answer
How's
that when I come back. Thanks for all the questions, it's been fun.
Write it down.
May it please the court, my name is Shawna Reagin. I'm from the Harris County District Attorney's Office representing the state of Texas. The question presented in this case is whether selection of a jury is an ultimate judicial determination that only elected district court judges can make under our Constitution. The short answer to that is no. Our Constitution gives the legislature broad powers to create courts, to regulate the jurisdiction of courts, and to authorize associate judges to conduct certain actions upon a proper referral order from the elected judge.
I'm with you for the first 2/3 of what you said there. So they did create this court, right? And Article 5, Section 1, how much of the power of the judiciary does it put in the courts of this state?
The power is in the court.
100%, right?
Yes, sir.
Okay. Article 7 creates district courts. This was a district court, right?
Yes, Your Honor.
And it provides for who is the judge of that court. And it's not an associate judge, right? Where in Article 5 did it authorize the legislature to impose the power or the accountability on someone other than the judge of the district court for a final determination in a case?
Judge Schenck, it's our position that the power does not leave the elected judge. The elected judge retains the power and the authority and is acting only through the surrogate of the associate judge. The associate judge has no power within him
Okay,
or
but the
herself.
statute authorizes, or purports to authorize, the assigned associate judge to conduct the voir dire. The U.S. Supreme Court and Gomez made the point that, and I think it seems to me correct, it's a little hard to reevaluate all the rulings that would be made during the course of jury selection after the fact, when a bunch of the jurors have probably been dismissed and gone home.
And that is, I believe in Peretz, the court then said that they would leave that problem, they trusted the district court judges to deal with it when that problem occurred,
With consent.
with consent.
And there's no consent required in the statute, correct?
No, Your Honor, but it is implied, is what's missing in this whole thing, and which has been so obvious to me from the get-go, is if you're a lawyer practicing criminal law and you have a problem with something going on, you make an objection. This particular case, I think is highly instructive on all the questions that we've heard here today, is because of what happened. They did go to the elected judge when they were unhappy. They got everything they wanted throughout voir dire. Nobody objected to the rulings. It's typical in Harris County that many of the challenges for cause are by agreement. When the associate judge did not go with the defendant, with Mr. Baptiste, his lawyer took it up with the elected
But
judge.
this case is about, as your opposing friend says, the power of the judge to act at all. How could the objection or non-objection have any relevance to that question? If the legislature doesn't have the power in Article 5 to create a new and different judge of that court, then why would the objection matter at all?
Well, we would argue that the legislature does have that power through
I
the
get you, but if you're
Constitution.
not right about that, then why does the objection matter at all? What would the objection accomplish? In the trial court, for instance, if I understand your brief correctly, the argument had already been rejected in the Houston Courts of Appeals, right?
Which argument?
The argument that the associate judge lacks the authority to conduct this aspect of the proceeding.
It had, but the fact that a position has been rejected by the courts of appeals has never stopped anybody from raising it again if they felt like it was applicable to their case.
Counsel, let me direct you just quickly. Focus for me on this question. Counsel is arguing that because of the jurisdictional nature of this issue, Karanov doesn't apply. Address that for me. Why is an objection necessary? Why doesn't Karanov apply here?
It is not a jurisdictional issue because the court still had subject matter jurisdiction over the case. It had jurisdiction. I believe that petitioner himself admits this is not a jurisdictional issue. Therefore, the judgment is not void. That the plain language of the Constitution says the legislature has this authority.
Where
does
does it say
Karanov
that?
apply or no?
Pardon me?
Go ahead.
Where does it say that? You're saying the plain language says that the legislature has this authority in Article 5. I've not been able to find that plain language in my own reading.
Actually, Judge Parker, we're in a couple of different places. In Section 1 of Article 5, it says the legislature may establish such other courts as it may deem necessary and prescribe the jurisdiction and organization thereof.
But this is a district court, right? Is there any district court in the state that's not elected?
Not that I know of. Not, I mean, sometimes temporarily, but they always have to run for election as soon as they can.
How does this undermine the will of the people in terms of having an elected judge hear your case? It seems to me that's what this constitutional provision is about, and I'd like to hear your thoughts on that.
I don't believe it does undermine the will of the people. I think the Constitution is clear in that regard. And again, the elected judge did hear the case. The elected, I'm sorry?
You heard parts of it, right?
Well, trial didn't really commence until the jury was sworn, which the elected judge did that.
Well, jeopardy didn't attach.
Well, jeopardy attached, and generally voir dire has not been considered part of the trial on the merits of a case.
So imagine a scenario where the defense was very unhappy with virtually every ruling the associate judge made during the voir dire process, and then the case comes to the elected district judge. The judge is getting ready to swear that jury panel in to attach jeopardy and go forward with the trial. Couldn't the defense at that point say, Judge, we object to swearing in this jury because it was an associate judge who did it, not you, and by the way, they messed it all up. Why couldn't they have done that? And at least wouldn't they have the remedy at that point of having the district court judge bust that panel and start over again?
They can do that, Your Honor, and I've heard of similar instances happening in Harris
What in the
County.
statute says they can? Where does the statute say that? What standard does it provide for review of the associate judge's decision?
I mean, at any time, either party could object to the panel before it's been sworn. In fact, that question is
No, I'm
usually
talking,
asked.
I'm trying to elucidate on Judge Urie's question. If you're unhappy with something the associated judge has been doing during the jury selection, does the statute authorize review of the decisions that he's made with respect to juror number 5 or juror number 12, or the amount of time that was allotted for and what would the standard be? I didn't see that in the statute.
The part of the statute that generally allows for review within 30 days, and I understand the problems caught up in Peretz and all that, is that how quickly it goes. I mean, it's not like you have a motion to suppress and then either side can go petition what we call the real judge to see, to review what the associate judge has done, and after 30 days it becomes final. We don't generally have that gap between voir dire and starting the trial, I agree. But again, there's nothing preventing, nothing in the statute says you can't speak up. And I think the section of the statute that says at any time, which you also, I think, see this in the civil applications, at any time, with or without an objection from the party, the associate judge can refer the case back to the referring judge. I read that to mean that you do have that option. You can object. It's up to you to object if you're unhappy with what's going on. To come in afterwards, and I find it interesting, Mr. Wood was talking about statutes that are the penal statutes on their face, which we were talking about in Karenov, and Judge Cochran's concurrence was very instructive to me on that because, well, she pointed out they didn't really challenge the facial constitutionality of that statute, but she was drawing a clear line between, hey, it's one thing if the language that you were just convicted under is found to be unconstitutional for First Amendment reasons or whatever, as opposed to, in this case, it's more of a procedural type statute. It's not something that you just look at the indictment and look at the statute and say, hey, this is facially unconstitutional. There's a conflict. You don't see that conflict in the plain language of the Texas Constitution here and the statutes themselves. I sense you disagree with me.
Mr. Wood's point about the explicit delineation of, and there's a bunch of Article 5 that's potentially triggered here. Let me just ask this question. Is the associate judge the judge of that district court?
No, Your Honor.
Okay. Is this a court of countywide jurisdiction?
Yes, Your Honor.
Okay, what does Article 5, Section 30 say about judges of those courts? I can tell you.
I think I read that last night, but I don't remember.
They must all be elected, all of them, right? And then in Article 5, Section 7, that last sentence is going to be talked about in a little bit. You maybe want to get into this about visiting judges. But it says a legislature shall provide for another judge when the regular judge is unable to preside. I don't see in there anything about one judge swapping in and coming in and out. And to put my cards on the table here with you, Article 3 of the U.S. Constitution creates less of a problem in this context than I think Article 5 does in our Constitution, because we don't have the overlay of the mandate of electing the judge of the court and the requirement that somebody is presiding. And I don't see anywhere in our Constitution where we have the trial being presided over by a tag team match between someone who is accountable to the voters and someone who isn't. And if in the federal system, Article 3 has been construed to not allow a magistrate judge who is an Article 1 or non-Article 3 judge or a bankruptcy judge to be handling dispositive matters or any matters without consent of the parties, how we don't have that problem but worse in this setting. Do you understand my concern?
I do. I read the Peretz line of cases, the cases cited therein, to include, they seem to be using equally the terms did not provide written consent and failed to object. So again, we have, as I'm sure you well know, many cases where fellow elected judges will tag team in and out. Somebody's got to leave before they take a verdict. Somebody does punishment when the first person did guilt innocence. You know, maybe those are elected, but we go back to, I mean, the Constitution doesn't define absent. It says the legislature shall also provide for the holding of district court when the judge is absent or from any cause disabled or disqualified from presiding. So absent could be elected judge is running his or her docket on a daily basis while visiting judge.
Don't you think that's extreme, though, interpretation of that provision? When you read it in context, it says absent. It also mentions disabled or disqualified. It seems a stretch to me to say the judge is absent because he's not going to be the one that conducts this and he's got these associate judges that are provided. Do you really think that's what the Constitution meant at the time? Or did it mean he was absent because of sickness or time off or emergency? Those things seem to be much different than I'm absent because I've got someone else to do my job.
Well, I don't know what it means because the Constitution doesn't define what it means. I'm just looking at the plain black and white language. If the judge is absent, it has not been defined. We can go, you know, that then starts kind of a slippery slope of, well, how long do you have to be gone?
That's exactly what I want to know, that slippery slope. If you're going to interpret Article 5, 7E to mean that when the legislature shall also provide for the holding of district court when the judge thereof is absent, to be a justification and a legal basis by which an associate judge can act, where does that end? Can then the associate judge not conduct the trial or do anything else? If the 7E is going to stand for the proposition that when the district judge is absent, the associate judge can do, can act for them, then where does that get limited?
Well, their actions are limited by the statute itself. I mean,
This is the
statute,
Constitution.
right, but we're talking about the statute that we're talking about.
Okay, so
it does not give them the
could the
right
legislature pass a statute that says the associate judge can conduct the trial?
Well, to borrow from my learned colleague, we'd have to cross that bridge when we come to it.
No, and that's what I was going to ask is, I mean, if the Constitution says the legislature shall provide for the holding of district court, you know, when the district judge is absent, I mean, doesn't that sort of imply that the person that the legislature is going to sub in for is at least as qualified to do the job? And qualified probably means either elected at some point, because you can't be a visiting judge unless you have a certain amount of years, and those amount of years, unless you're just serially appointed all the time, those amount of years are probably going to involve you winning an election at some point. I mean, can't we make that sort of common sense assumption that at least as qualified as the person that's absent?
Again, we can say probably, but that language is not in there.
Well, it does, the Constitution just says, make a distinction between courts and judges of the court in, I think, 3 places. And with respect to district judges, they have statewide authority, according to Section 12 of Article 30, right? So if we're subbing one judge in for another, I think Nathan Hecht, Chief Justice Hecht, had to deal with that in a visiting judge objection where he was taking an active judge from one part of the state and dropping him into another, and the objection was, well, he's not from this county, to which I believe the answer was, well, a judge of the district court is a judge with statewide jurisdiction. So that's perhaps less of an acute challenge. But here what we've got is, I think you're conceding, maybe you're not, that an associate judge is not an Article 5 judge.
Yes, I'll concede that.
And
But-
subbing him in for part of a proceeding in a district court is, I'm looking for where in Article 5 that's consistent with the text in some way.
Well, first of all, I mean, Article 5, Section 7 doesn't mention visiting judges either. So these are just adding words into the Constitution to say that. Yes, under our rules, to be a visiting judge, you have to serve 2 terms and meet various...
That's the invitation at the last sentence of Section 7, right? The legislature shall provide for...
Shall provide, and it doesn't say, it gives them the authority to do that. It doesn't say you can't have associate judges. It doesn't say you can't have, or you must only have visiting judges. And like the example that I was going to cite is, at least it's common in Harris County, is the elected judge may be picking a capital voir dire, which takes a while, and they have a visiting judge in the same building running their daily docket, or vice versa. Is that absent? No.
Counsel, what I'm hearing the argument to be with these constitutional provisions is that these constitutional provisions seem to specifically lay out specific ideas that a judge or court can do. Is there text, or what text do you rely on that can say the legislature is nevertheless empowered to create associate judges?
The authority I'm relying on is the authority that gives the legislature the authority to prescribe the jurisdiction and organization thereof.
Right,
It
right.
seems
So,
to-
so there's this kind of this catch-all legislative thing at the end that allows you to expand beyond the limited list of what a judge could do in the constitutional provisions,
Yes.
right? Right?
Not, well, as to what the elected judge can do, I mean, this is unlike the case where Arkansas tried to change term limits. The legislature here has not altered the qualifications that are required by the Constitution for the elected judge. And the statute itself then provides for different qualifications, which there's been no showing that this associate judge didn't meet.
So you would argue, you would not argue that, or you don't agree with defense counsel's argument that the legislature just can't pass this statute whatsoever because there is some provision that allows the legislature to step in and make provisions concerning the terms of the court and jurisdiction and things like that.
Yes, that is
So that general legislative grant allows this kind of thing.
They have traditionally had broad authority in that regard. And again, because the legislation itself limits what the judges can do, and the referral order itself will further limit what the associate judge can do, you have your safeguards, just like you would if an elected judge screws up or if a visiting judge makes a mistake. We still have the appellate process as well, just like this associate judge.
Just like say the Attorney General walking into court as a prosecutor?
Hypothetically,
Hypothetically speaking.
But there's other things in this statute, like an examining trial. It says that the associate judge can conduct an examining trial. Is there a provision for review of that?
Well, traditionally, back when you still had them, if somebody didn't get the case indicted and you actually had an examining trial, if the state felt like that say the judge granted the dismissal, or, well, they can't grant dismissals, so I'm not sure. Apparently, their rulings are probably just advisory even on an examining trial if they find no probable cause, just like on the motions to suppress. These are all kind of interlocutory, like you said. And again, there's nothing to prevent voir dire from being that same way. Is the judge, it's party-driven, and just like happened in this case, if you're unhappy, you speak up, and before the jury is sworn, you get to complain. Both sides get to complain, and it's happened before, and I'm sure it'll happen again. And you don't always have to bust the panel or dismiss the jury. In this case, they actually let a juror go who had become problematic. It happens a lot, especially over a weekend, and replaced with another alternate.
Is more than, is text. We're looking at the text of the Constitution, where it would purport to authorize this, the text of the statute that would purport to provide the solutions. You're saying that, well, the tradition is out there, we've always done it this way, maybe there's review, maybe you can go to the trial judge after you've done the voir dire. I mean, that's the challenge here, because I'm focused on the text, and I'm looking, as I see it, what I find a problem relative to the Article III judge's treatment of other people, and now we've got the overlay of an elected judge with text that addresses that.
I agree with Judge Shank. So isn't the overreaching problem a separation of powers issue? So has the legislature not encroached upon what's been set out here for the judiciary in terms of an elected judge's responsibilities? The only way you get around that is looking and expanding the definition of absent.
I'm out of time, may I reply?
Oh, of course,
Oh,
go,
yes.
please.
With regard to the separation of powers, although that argument has not been raised, I've been looking at it quite a bit, and this isn't a situation like
Have you read Stevens? Maybe you should.
Always, Your Honor. I read Stevens at least once a month. I take that case to bed with me at night.
Do you read the dissenting opinion in that case?
Yes, Judge Erie. Is, just like the situation on rehearing and ex parte low, a favorite of everyone I In Ex parte Low, the court pointed out, they found that an encroachment when it said, hey, you can't do this without going to the Attorney General in the executive branch. That is an encroachment. I think it was armadillo bail bonds, you know, setting time limits on telling the court, you may not do this, you may not do that, on a core judicial function such as entering a judgment. And that's not the case here. This, again, is a carefully controlled, it's not a separate, the legislature is exercising the power that it's given in the Constitution by passing these statutes that we presume to be valid.
By interpreting the word absence to include the existing district court judge, it's still presiding over the case and made the appointment, and you can run to him maybe across the hall to handle something on voir dire, but he's presiding too, and he's absent at the same time.
I don't know what absent is intended to mean. I'm just saying, that all I can look at is how it has done in
If this statute's
practice.
constitutional, then why couldn't the legislature pass a statute that would confer on me the power to declare my colleagues absent if they're voting in ways that I don't approve of?
I thought you already had that power.
But in theory, they could do that, right? That would be
Well-
a power to declare people absent.
And each statute, I mean, again, that statute would be examined. Are they encroaching too much onto your core judicial function as a court? This is about the court versus the individuals that are in it. The power resides with the court, and the power in this, I thought of it as I was reading the cases, the elected judge is like the fountainhead, or more
It
simply,
isn't
it's,
the purpose of electing the judges that the power resides in a person elected by the people.
the authority, but not the power per se. It doesn't go with the individual, it goes with the court. And
Aren't they the
elect-
same?
So is the power to assign an associate judge, does it come from the elected district judge or just from the regional presiding judge? Or who?
Yes, no, it is, in Harris County, and again, the system is now gone, but once the associate judges became available, and it wasn't one per court, it was a group of them, is each individual judge would do a referral order to the court. We had a little controversy once on the judge referred, the referral order had one cause number on it, and the associate judge picked the jury, but the elected judge didn't want to hear that case, and that kind of turned into a kerfuffle because what had been assigned versus what had been intended. But the associate judge, again, is just that judge's surrogate. I have to do what this judge has told me, and I have no power or authority beyond that.
Perhaps they
Beyond-
just need a staff attorney.
Well, they have a few, but again, it's not the encroachment. It's the judge. I thought of it too, kind of like a non-durable power of attorney is if you die or if you're not there, then it doesn't work anymore and your person, your designee, doesn't have any authority. Here, it's coming from the judge who was elected by the people. And nothing in the plain language of the Constitution mentions associate judges, mentions voir dire for that matter, or mentions visiting judges. So that goes back to that can of worms.
What do you do with our sister court has said that jury selection is within the province, that it's particularly within the province of the trial judge, quoting a U.S. Supreme Court case. I mean, basically you're saying voir dire is not that important of a part of the trial. We can put this over here with the associate judge. So that's a pretty sweeping statement to say that there's not ultimate judicial decisions made during voir dire. How do you address that?
I'm not saying at all that voir dire is unimportant. I think it's very important for the parties. But again, in federal court, voir dire, the judge at voir dire has a slightly different role than in state court where it's very much parties driven. Again, by statute, the parties make the decisions, the parties do this. But it is telling to me that even in the federal arena where the trial judge has just all the power and does all the voir dire for the most part, is that they are willing to allow a magistrate judge to oversee that part of the trial.
Not unless the parties have been asked and consented.
They do.
That's
But also,
not required here, right?
but again, you have the option to object. I don't think anyone
Question
has.
for you. I know you're out of time, but a question for you. Coming from a criminal defense background, I can tell you personally, you can win or lose a criminal trial in voir dire. Do you disagree with that?
I don't at all. I have 20 years as a defense attorney.
So you understand how critical voir
And
dire
that's
is.
why I said I am not saying that voir dire is not important, but it's important to the parties, and the rights go to the accused. So yes, the parties want to get in there and know, what are you people thinking? This is the case that's going to go on, the state too, for that matter. This is the case I'm going to present. As a judge, a lot of judges prefer to do their own voir dire because you want to know who you're sitting through that trial with, and you want to have that kind of control. Just some judges apparently, for whatever reason, and we're not privy to that because it doesn't say why they didn't do it, designate the associate judge. But again, the elected judge has ratified whatever proceedings the associate judge has conducted by swearing in the jury, and that's what starts the show.
Would you agree that the elected judge is more likely to be aligned with the sentiment or belief system of the county he's elected in than a associate judge picked by whomever?
Sometimes. If there are no further questions?
Counsel,
Yes,
I'm
sir.
very grateful to you, I'm sure we all are, for your indulgence. You're sticking with us. Very interesting case, really well argued, and we
Thank
have a few more minutes from your opponent.
We pray that you will affirm the conviction below. Thank you.
Thank you.
May it please the court. First, really good job, Counselor. She's got lots of experience. She's a former district judge in Harris County. She knows her stuff and she knows what's going on, and it's a pleasure to have such an intelligent
So do
exchange
you.
here.
Don't sell yourself short, buddy.
Well, thank you, Judge Newell. I wanted to get back to where we left off with Judge Richardson. He had two questions. I think the second one is the biggest of the questions, and that had to do with visiting judges. And I know you've got a special interest in this because you have a long history of being a visiting judge. And visiting judges are envisioned by Section 7 of Article 5, and that's in subsection E. And we've already talked about this a little bit during Ms. Reagan's presentation, but that says that the legislature can allow and they can do something to allow for when the judge is absent, disabled, or disqualified, so that court can continue.
It doesn't say what they can do though, right? I mean, it says they can do something. It's kind of vague, isn't it?
What is the exact language?
Yeah, it says the legislature shall also provide for the holding of district court when the judge thereof is absent or is from any cause disabled or disqualified from presiding.
Okay, thanks, Judge Uri. And see, I think they have provided for that by the system.
I mean, why wouldn't that also apply to an associate judge? If they can do it for a visiting judge, what's the limiting principle? I don't understand.
Okay. This is gonna take me a minute to argue, to answer the whole thing, and it's part of what I'm answering for you, Judge Richardson, is that a visiting judge, the whole system, and you read about it in Chapter 74 of the Texas Government Code, the whole visiting judge system is to solve that issue when there's an absent, disabled, or disqualified judge. And they allow for visiting judges to do everything, every aspect of the case. Judge Richardson, you know that, having sat so many times as a visiting judge. You do everything. There's nothing that you need to go get approval on, okay? Associate judges, that's not the kind of thing that's envisioned in Section 7, Part E. Associate judges, the legislature seems to understand that they have limited authority. That's why there's a limitation that they say you can do this, 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 and this, but you can't conduct a trial on the merits, so on and so forth.
So if we buy off on your argument that the proceeding is just totally void with an associate judge, if they've been involved in the jury selection process, aren't we just opening Pandora's box for all of these convictions that resulted in an associate judge being involved in the jury selection process?
Well, like I said, that's a question for another day, Judge Richardson. I'm here on.
It might be today, because, I mean,
Okay. Look,
they
I
have to solve
understand.
that. I mean,
Today's the day.
Today's the day.
maybe not for you, but for us.
Do we have
You put a
control
dime in
over
the
retro-
jukebox, you gotta let the whole song play out.
Do we have
That's a good one. Yes, sir, Judge.
over the retroactivity of our decisions, particularly decisions on constitutional law, if we set a new rule of constitutional law, and whether it was, we might say later, it was foreseeable given the plain text? It would
You
not
know-
be necessarily retroactively available on habeas, for instance.
Retroactivity, boy, that is a Pandora's box if there ever was one. And I do understand.
That's it.
Yeah, you go back to Nix versus State from 2001, and it talks about if it's not a new rule, then it's retroactive. If it is a new rule, then there's a balancing test. It's pretty involved. And so, Judge Richardson, to answer your question, yes, I mean, if you rule the way I'm suggesting you rule today, that's something that down the road somebody could try and advance, perhaps even on a writ of habeas corpus. You know, I don't know. And wasn't really mentioned today, but in the briefing by Ms. Reagin, she mentioned that, wow, there's associate judges in family law cases, juvenile cases. Maybe this opens a box to some of that, whether that's okay.
It would, what you're asking us to grant would create a reign of writs.
And a potential rift between this court and the court that sits across the hallway over there as well.
Really?
Well,
I mean-
you just said there's associate judges and all
Oh.
kinds of family law
I
matters.
see what you're saying.
I've asked both counsels, I don't think I've gotten an answer. I believe if I read that statute correctly, you have to have de novo review in the civil setting, and there's consent features in the family code provision, if I remember correctly.
So-
But maybe I'm wrong.
No, Presiding Judge Schenck, I'm out of time.
You can
Can I go on a little bit there?
Please.
There's chapter 54, there's chapter 54A, there's chapter 54B. They create all sorts of different magistrates, masters, associate judges, referees, hearing officers, all these kind of things. Each one has its own provisions, each statute about how they are appointed and so on. And so they all stand on their own. There's all these different things that would have, you'd have to consider the facts in the statute in every case. All I can really say today is what we're talking about is associate judges in criminal cases. To what Judge Parker said, yes, if we allow this to happen, we are devaluing the role of a district judge. I drove up here yesterday on 290 in Lee County, in Bastrop County, in Washington County. Everywhere I went, there were signs on the road saying, elect so-and-so to be a district judge, because you know what? And Judge Reagin will tell you this, she was a judge. It's a really big deal to be a district judge in Texas, and the judicial power has been given to them. The fact that there's nothing in Article 7 that, in Article 5 that says associate judges can't be appointed, that doesn't matter, because the entire ground is covered by the Constitution. And I point you to a very key case. I'm going back to 1877. 1 year after the Constitution of the state of Texas was put in place, it's ex parte tolls, and that's from the Texas Supreme Court, and it said the framers sought to, quote, mark out a complete judicial system. That's what we've done. You can't add to it. And with that, I will close. And thank you for your attention. This has been, like I say, fun, very interesting. And I ask that you will declare this judgment against Mr. Baptiste to be null and void.
Thank you very much to both counsel. We very much appreciate your arguments, your fine briefs. It's a very interesting case, and you've been very helpful. We appreciate it very much. And with that, this case will now be taken under submission, and the court will stand in recess until we're...
All rise.